collector. So my lord, only by given this have been decided. My
The
lord.
collector has no authority to decide it under the act. SARFAESI Act में देखिए कहाँ है? They have no authority in law.
Not party before the court, before the collector. I cannot mortgage the property.
No, fine. That is, but they are not supposed to go into all that question. They cannot go under the law. 14 order has been passed.
My lord, no notice given, and now they are initiated taking action in that order. My lord. We have filed the order, annexure. Before is the order, my lord.
Where is the section 14 order?
My lord, page 51. My lord, यदि श्रीवास्तव जी पक्षकार हैं, हमारा हम पक्षकार नहीं हैं। यदि श्रीवास्तव को ही मॉर्गेजर माना जाना है और हम प्रॉपर्टी के ओनर हैं और हमारे मकान में आके वो नोटिस फिक्स किया गया है अभी माइलॉट अनेक्चर P5, जबकि उसमें भी नाम माइलॉट यदि श्रीवास्तव का लिखा जा रहा है और प्रॉपर्टी हमारी है, वो गलत मतलब मेहनत से हमारे के लिए उस ऑर्डर की उसमें कर रहे हैं।
तो आप बीआरटी जा सकते हैं?
बीआरटी माइलॉट पार्टी भी नहीं है, नेसेसरी सफर करेंगे और लेंदी प्रोसीडिंग में माइलॉट और भारी एक्सपेंसिव प्रोसीडिंग माइलॉट कोर्ट फीस भी वहां देनी पड़ेगी 46 लाख का, तो उन्होंने लगाया है माइलॉट। वो अननेसेसरी माइलॉट और ऑनरेबल कोर्ट सुप्रीम कोर्ट ने कहा है माइलॉट कि अगर प्रोसीडिंग जो है तो इलीगल कर रहे हैं उसके उसमें आपको 26 में आ सकते हैं माइलॉट। दिस इज द ऑर्डर पास माइलॉट लेवल सुप्रीम कोर्ट इन केस ऑफ कमिश्नर इनकम टैक्स पच्चीस काबिल दास अग्रवाल माइलॉट ACC 2013-56 in para 16 माइलॉट ऑफ द ऑर्डर ऑनरेबल कोर्ट हैज ऑर्डर टू टेक द एक्शन।
What is the pre-deposit there? Pre-deposit क्या है? सेक्शन 17 में अगर आप जाते हैं सरफेसी एक्ट में तो प्री डिपॉजिट कितना करना पड़ता है?
About 125 rupees per lakh and first 10 lakh पे माइलॉट 5,000 कोर्ट फीस। ये लेडी है माइलॉट अकेले रह रही है हाउस में, नोटिस पेश कर गए हमारे घर में और बोल रहे हैं कि आप खाली करें। भाड़े में दिखा जाए माइलॉट कुछ भी हमने अपना टाइटल डीड बनाया देखते हैं।
प्री डिपॉजिट का कहाँ है इसमें?
उसमें है
एक्ट सेक्शन 17 में बताइए कहाँ है प्री डिपॉजिट? सेक्शन 17 सरफेसी एक्ट में प्री डिपॉजिट का कहाँ है?
कोर्ट फीस अगर अपन लगाते हैं जैसे एप्लीकेशन माइलॉट उसमें कोर्ट फीस देनी पड़ती है।
फीस का कहाँ है बताइए? पास ओवर में आइए, पास ओवर
नंबर दीपक पंजवानी।
pass over. The first appeal against what? Section 27 by the husband. 27 would be, oh yes, yes, है ना? रिजेक्ट हो गया। डाइवोर्स कैसे था? स्पेशल मैरिज एक्ट। Where is the special marriage act? This was a case under 27 of the Special Marriage Act. What is section 27? No, what is that? Yes, yes. So that is divorce, seeking divorce on the ground of cruelty. 1D. That has been dismissed. All right, so we call for the records. Notice record. Your name? Okay. Notice record PF 7 days.
Number 7 CCS only.
Yes. Custody के लिए और custody maintenance by whom? By the wife. Respondent. Who is the respondent? Father. So that has been rejected. And what is the interim or relief you are seeking? Something was directed in the family court. Some interim order was passed. Interim maintenance. We will issue notice on that. Notice PF 7 days on admission as well as interim relief. Record be requisition. List in the week commencing 13th May. Let the other side come. On 13th we'll decide. 20th May.
Number 8 Kirat Raj Pillai.
How much? But how is this appeal maintainable? No, the larger bench says that no appeal lies against section 24 order. Where is that order? Where? How do you get that? All right. So this is this full bench is 2022 volume 2 MPLJ. Please see that. 2002 volume 2 MPLJ. Page 467.
Number 9 C Dhananjay Shukla.
All right. Notice record PF 7 days.
Number 10 CCS only.
All right. Notice record
Number 11 C Shiv Kumar Kashyap.
Yes. So 913 filed by the wife has been dismissed. Record है? Record आ गया?
Yeah.
Record is here. Who is for the other side? आए हैं कि नहीं आए? चलिए पास ओवर करते हैं. पास.
Number 12, Sri Santanu Ayasi.
My IA is also pending. There is some approximately for 33 days.
All right. Delay condoned. Notice record. We have 7 days.
Number 13, Sri Madan Singh.
Well, this appeal is in fact, none of the bike. Therefore, matters for divorce is being allowed.
On the ground?
On the ground of matters effect, severity and suspension.
Oh,
First time.
that was allowed.
Yes, madam, that was allowed in the bike.
Hmm.
And my lord, actually, what happens this matter, if also by the application, under section 25 of the new marriage act, of permanent element. Therefore, my lord, the trial court my lord has allowed the application and granted full like fees my lord towards permanent element. Right, of fact that my lord, she is already getting a maintenance under section 125 proceeding.
She had filed an application
Yes, yes,
under 25.
25.
All right.
In this, my lord, if my lord may please to see the order of maintenance, my lord, but
So which part of the order you are challenging?
I am challenging the part of permanent element.
Only. You are not agreed by the divorce.
My lord, in fact, what happened is that initially, was from the last 10 years.
No, you are not agreed by the
Yes.
divorce.
That is page number 20. This is the judgment where my lord she is getting. And this,
This is under 125.
yes, yes,
How much?
other 2,500
Per month?
for the present plan is the labor rights.
So that permanent alimony must have taken this into account. While passing the permanent alimony order, the court must have taken this 125 order into
Well,
account.
in fact, the 125 order was taken, the proceeding was taken into consideration, but that I decided in the quantum that she's already getting a maintenance, no finding has been given. And the trial for this. My lord, my please to take. The judgment, my lord, they say that she's already getting a maintenance, but no description has been given why the justifying this amount is to be paid to this whole length. Despite the fact that she's already getting a maintenance of 2,500.
Which para?
My lord, if my lord may please to take. The reason, my lord, which is, in fact, if my lord may see this one. Para 16, my lord. Page 18. Actually,
16. Yes.
याचिकाकर्ता द्वारा पंचायती के विरुद्ध ध्वनि घोषणा का पत्र प्रस्तुत किया गया था जिसमें दिनांक 11/5/23 को 2500 रुपए पंचायती के खिलाफ करने का आदेश न्यायालय द्वारा पारित किया गया। अभी साक्षी के मान द्वारा प्रतिपक्ष में स्वीकार किया गया सामाजिक में पंचायत के बाद अपनी याचिकाकर्ता और प्रत्यक्ष द्वारा विभाजित याचिका
इसमें दोनों पक्ष में प्रारंभिक कथन किए गए थे। आवेदक की ओर से प्रस्तुत फीस में कथन लगाया कि 4 के दस्तावेज के अवलोकन से स्पष्ट है कि प्रत्याशी और याचिकाकर्ता द्वारा आपसी सहमति से धारा 13 भी क्षेत्र याचिका पर उक्त याचिका में याचिकाकर्ता कल्पना पटेल और प्रत्याशी जितिन पटेल की दिनांक 4/2/2020 को कथन दी गई। कथनों के अवलोकन से दर्शित होता है कि 3,30,000 रुपए प्रत्याशी द्वारा याचिकाकर्ता को दिए जाने पर विवाह विच्छेद की डिग्री बात की जाती थी, किंतु प्रारंभिक कथन लिखित किए जाने के 6 माह पश्चात 22/9/2021 को प्रत्याशी के न्यायालय में उपस्थित होने तथा कथन लिखित कराए जाने से सहमति से प्रस्तुत विवाह विच्छेद की याचिका नजर उक्त तथ्यों का रामचंद्र पटेल से भी कथन से होता है। नाउ माय लॉर्ड दिस पैरा दिस माय लॉर्ड 22 याचिकाकर्ता की रूप से 18-25 भू विवाद अधिनियम के अंतर्गत स्थायी निवारक के रूप में 10 लाख रुपए प्रत्याशी से दिलाए जाने का निर्देश किया गया, किंतु उसके द्वारा इस संबंध में साक्ष्य स्वीकार किया गया है कि उसे 3 लाख रुपए नगद दहेज का सामान जेवर आदि दिए जाने के संबंध में जैसे इम्पोर्टेंट कोई भी साक्ष्य दस्तावेज प्रस्तुत नहीं किया। Any dowry or any ornaments were given, there is no evidence to that they were not abused by the parties, neither have been abused by the wife. एंड विवाह के खर्च किए जाने के संबंध में कोई बेल सामान की शादी प्रस्तुत नहीं की है। विवाह सम्मेलन से विवाह किया जाना स्वीकार है। मानो इट वाज अंडर द विवाह सम्मेलन दैट वाज कंडक्टेड अंडर द मुख्यमंत्री योजना दैट्स ऑल डन। एंड याचिकाकर्ता की ओर से प्रस्तुत 3 के दस्तावेज जो सहमति से प्रस्तुत विवाह विच्छेद की याचिका के समर्थन में प्रारंभिक कथन लिखित है उसमें प्रत्याशी के द्वारा दी गई साक्ष्य दर्शित है कि 3,20,000 रुपए नगद दिए जाने पर सहमति से विवाह विच्छेद की याचिका में निराकरण होना था, किंतु अंतिम कथन के समय प्रत्याशी के अनुपस्थित रहने से आपकी सहमति से विवाह विच्छेद याचिका में निराकरण नहीं किया जा सका। याचिका निरस्त कर दी गई, जबकि याचिकाकर्ता उपस्थित थी। जाति द्वारा संस्था में 3,20,000 रुपए याचिकाकर्ता को दिए जाने की सहमति दी गई थी। इसलिए न्यायालय के मत में सही निर्धारक के रूप में याचिकाकर्ता को प्रकरण की परिस्थिति देखते हुए 4 लाख रुपए प्रत्याशी से दिलाए जाना उचित प्रतीत होता है। एंड आवेदक की ओर से धारा 27 अधिनियम के संपूर्ण स्टेटस से दिलाए जाने का निर्णय किया गया, किंतु के द्वारा इस संबंध में साक्ष्य में स्वीकार किया गया कि उसने सोने चांदी के जेवरात सहित दहेज का अन्य सामान आदि दिए जाने के संबंध में कोई दस्तावेजी साक्ष्य प्रस्तुत नहीं की गई और विवाह सम्मेलन से किया जाना भी स्वीकार है। The line of the father, the part has been declined to that extent. In fact, the light man of 3,20,000, the final settlement was to be made.
क्या मतलब है? इनको कंसिडरेशन लेने के बाद उन्होंने कहा कि 4 लाख अरे 25 में ऑर्डर हो गया फाइनल, इसमें समायोजित तो करनी जाएगी। 124 ऑर्डर में ये लिखा है, अगर किसी और प्रोविजन में ये मिल रहा है तो ये समायोजित मानी जाएगी। 125 ऑर्डर में लिखा है और उस वक्त तक ये ऑर्डर नहीं हुआ, आज नहीं हुआ। यस कुछ हम लोग once the 125 का और ये कब का है, इंक्लूड ऑर्डर कब का है?
26 to 24.
So that once the parties have agreed to finally go in for a permanent alimony, so don't you think that they have taken into account every other maintenance order passed in any provision of law?
What is going to say? If I don't make
Alteration.
what is that effective? 3,50,000 the final settlement was made.
They may not have said it, but
But my lord, this could
it is understandable.
But in the my lord, this could not have taken. But my lord, from the 2020 when she started getting maintenance, my lord, this can be gathered from the order of the maintenance code. But wherein my lord, it is from the 2021, from the date of filing, we are paying the maintenance code. Now, my lord, the fact remains, if my lord, the permanent alimony is joined over. So it would have been settled, it would have been settled at the cost of rupees like 20,000. But due to some unavoidable circumstances, could not taken place. And she is getting maintenance from the year 2021. Right now, my lord, this order was passed. In fact, there is no discipline and no finding has been given with regard to the this my lord warranting the grants of permanent alimony to be filed. Despite of fact, my lord, that section 9 proceedings we have filed.
All right, we'll call them and ask them. It is, I think it is understood that any other maintenance granted under any other act gets included in this permanent alimony.
Yes, this is the judgment of a referee. My lord, whether recently in the my lord, 2021 volume 2, my lord. Here in my lord, the Supreme Court clearly had said, the my lord, here in also my lord, the trial court family court effect granted a my lord permanent alimony. My lord, where was granted. Later on, my lord, the wife filed an application under section 125 seeking a maintenance my lord per month from the husband. So the maintenance was granted by the level high courts also. Therefore, my lord, the agreed party approached to the Supreme Court, wherein Supreme Court had said, if a maintenance has been permanent alimony has been given to a wife, then cannot take a further to that extent. And or vice versa. So, my lord, here in my case, my lord, is my lord it needs to see. Here and also, my lord, she already getting a maintenance on the other side. So, on the other side, and the permanent alimony is
So
also.
has she filed some execution petition?
In fact, yes, my lord, she is.
Where is the notice?
My lord, in fact, it is recently, my lord, I have received the instruction as per my instruction of the local council.
You serve upon them, we'll take it up early.
My lord, what is submit till then, till next week of hearing only, my lord, I am just seeking for a stay. Otherwise, she is getting maintenance. I am not disputing the amount of a maintenance is not being.
No, you are challenging that 4 lakhs because it's more.
No,
Uh,
my lord, I'm challenging the amount of.
Or you want that 125 order should be, that maintenance should not be paid by you.
No, maintenance I am paying and that may be go on. But the permanent alimony should be stopped. My lord, because she is getting a maintenance from me. This fact can be gathered, my lord, she is getting a maintenance. If my lord, be pleased to see the evidence I have also.
What are you aggrieved of? The quantum of 4 lakhs?
Quantum of the amount of a 4 lakh, my lord, which was granted by the trial court.
So you want how much? It should be 0 or it should be less?
My lord, it should be
0.
Yes.
Why?
I'm paying the maintenance to my life. From
Which?
2000.
That under 125?
Yes, yes.
So we'll say that is stopped then.
My lord, ultimately the payment from the last 2 years I am paying. The amount of rupees 1 lakh something I have already paid to her. Even if it.
Under the 125
Yes.
application, what was your reply?
125 application. But I have not with regard to the money, my lord, there was an order by the court finding and being given to in the sector. But
What was your response to the 25 application?
I don't know this phone for that. She is not deciding with us. Right, we find us like sitting under section 9 of our restriction of conditional right and the Hindu Marriage Act. There is a decree of the trial court against the wife that you should come and remain with the company. But she did not accept us. However, my lord, the duty which on the basis of the trial court has granted.
No, that the court has held that she's living away from you for reasons attributed to you, not to her.
But that she is deciding that voluntarily she is deciding. It is not on the account
No,
of my
for
court.
For reasons attributed to you. That is what the finding says. That is why section 25 order has been passed.
That's why I'm saying.
That you are not challenging.
The finding, in fact, so my lord, in fact, yes, the amount and to the extent finding, we are not agreeing with the finding which has been against us. Certainly, my lord, challenging, because on the basis of a debt finding, the amount.
We'll call for the record. Issue notice. We can't stay there.
My lord, still, because my lord, we are saying, with due respect, my lord,
No, please pay. Please pay. She's your wife. You are not paying it to a stranger. Please pay it. She is not your enemy.
No. Need to pay the maintenance. But my lord, so far as this quantum is concerned.
Please pay it and show your bona fides.
Otherwise, never time to create overnight because my lord, there is a too much extra there. Wherein my lord, this order would not be into existence. I have demonstrated on the record also. So why not till next date of hearing, why not like these two stay till next date of hearing only, otherwise why not till the.
What state you want?
I want the stay of execution of this.
For that execution, petition has been filed, you have received a notice, you will appear there, that it will take some time. It will not immediately happen. No coercive steps will be taken against you.
This may be also no.
So we'll say that we'll post it early.
Yes, yes, but
Let notice be issued on payment of PF within 7 working days. Record be requisition list for consideration of IA 5999 of 24. Applications also in the week commencing 29th April. What course? Please show us that there is a date fixed in the execution notice. This is the date. Coercive steps may be taken. She's your wife. Don't treat her as your enemy.
why I am paying the maintenance, I did not check it particular award. Because of that, I don't.
Even if you have to pay a few thousand to her, doesn't matter.
I don't.
It will go to your wife. Doesn't matter. Any children out of the wedlock?
No,
No children.
no.
Week commencing 29th.
Bill number 14C, Ravi Shankar Yadav, Umesh Kumar Mitra.
The divorce petition of the husband has been dismissed. All right, we'll issue notice. Actually, you are appearing or the wife. बताइए क्या कर record आ गया. Let record be requisition. Let the record come.
नाम बताएं. Again,
List after receipt of the record. Husband की divorce petition allow.
bill number 15, Srimati Nirmala Nayak.
Delay इसमें delay. Why possible? इसमें argument क्या करना है? To stay we grant you stay. Normal course we grant stay. लिखिए that let notice be issued on payment of PF. क्या नाम आपका? RS Patel on behalf of वकालतनामा में नाम है आपका? Notice PF 7 days per entry. Record the requisition. Meanwhile, the husband is restrained from remarrying till the next date of hearing. Returnable 6 weeks.
bill number 16, Ashok Kumar Soni.
Record of. Why should we call the record of the tribunal? वो तो आपको पेश करना पड़ेगा. We will not call the record. Don't order. ये MACP पे कोई डिसीजन आ गया है ना सुप्रीम कोर्ट का अभी रिसेंटली. ये उसी से कवर्ड है क्या? इसमें वो पेश करिए उसको वो ये पेश करिए. The challenge herein is to the order of the Central Administrative Tribunal. Let's pass. petitioner is directed to bring on record the pleadings filed by both the parties in the trial. Both the pleadings on record which were filed by both the parties in the trial. Just after 2 weeks. After 1 week. हैं आपके पास? इसीलिए आपको 2 हफ्ते दिए हैं.
10 days.
All right, 10 days.
Number 17, इतिहास से था तो फिर
प्रोविजन चैलेंज किया है आपने? Yeah. All right, कोई ऑब्जेक्शन है इसमें? ये इसमें डिफॉल्ट है, कुछ कॉपीज ये लगा दी आपने? देखना 27, 28. Nice. This was 39. 43, 50, 51, 50, 51, 57, 58, 59. 60. 59 or? Yeah. 60, 61, 69, 70, 29. 29, 100. 100 के बाद 104. 104 तक. 137 से लेकर 140. IAS also has been fined for ignoring the default of certain pages being not legible. Next, after perusing the record, it appears that the said pages are legible and therefore IAS stands allowed. The default raised by the registry stands ignored. उसके बाद वो admit notice stay final hearing.
number 18, से करने वाला
Who are you? A bank or financial institution? When did you file the section 14 application? Oh, 11? P1. P1 section 14 passed on to 11/23. Tehsildar notice. So the possession has not been given to you. Within 30 days, we'll say. If not given, not already given, then there is no legal impediment. disposed of.
Chair number 19 C Krishna Kumar Pandey.
P16 can. P16 is under challenge. Yeah, section 14 order. And who is the petitioner?
In favor of December that the loan has been sanctioned.
Borrower. He is the borrower.
Without loan has been sanctioned in favor of the bills. Number one is sanctioned, given to respond for construction of house. Never constructed any house, neither any single penny has been given to the petitioner. The petitioner has given number of applications to the higher authorities to conduct an inquiry. The corrector also injunction by, but the respondents they are key. Therefore, I am filing petitioner to conducting the inquiry, conduct of respondent number 1 to 4, whether loan has been sanctioned in favor of the never loan has been sanctioned to them. 84 persons are affected by way of such provision.
So can you go to the DRT? अभी एक केस आया था उसमें भी यही था.
सर इसमें DRT never can conduct such type of fraud which is taken by respondent number 1. DRT cannot conduct.
No, an order against passed under 14 can be challenged in DRT. There is no doubt about it.
और सर ये चंद्र का एडिशनल कलेक्टर है बात है. एडिशनल कलेक्टर हम नहीं सकते टू पास इन सब टाइप ऑफ.
Why not?
DRT है जो समझ टू पास.
Pasa 14 order. Please read 14. Please read section 13, section 14. नहीं वो एक्ट में दिया है, सेक्शन 14 में दिया है. Yes.
Regarding the activity done by respondent 1 to 4, by their provision manner, that loan has been sanctioned in favor of the petitioner, and entire amount has been given to respondent number 4 by number 1. Never given to the petitioner for construction of house. Neither any single interest has accepted.
यही सब इंक्वायरी के लिए DRT बना है. He cannot go into the merits in a SARFAESI matter.
सर देखेंगे आवेदन सर मैंने फाइल किया है 20 मोड से लेकर के by way of testimony given to respondents. Sir, number one, only neither the petition, 54%. I'm not filing on some others, but only one order. 84% the loan has been sanctioned for construction of house. Never any single money has paid to the borrower.
लेटर ऑफ ऑफर सब आपके नाम से है P3 P2 P3 आपका नाम नहीं है भवन निर्माण हेतु अनुबंध पत्र P2 इज लेटर ऑफ ऑफर बैंक द्वारा है वो फाइनेंशियल इंस्टीट्यूशन द्वारा है 1,70,000 आप ही को दिया गया
इसीलिए सर मैंने रिक्वेस्ट किया है कि वो जो पैसे हैं ये borrower के अकाउंट में गए ही नहीं करो गए ही नहीं.
That is why all these disputed questions of fact, उसी के लिए DRT बना हुआ है. Petition assails the order passed by the additional district magistrate under section 14 of the SARFAESI Act. Next for that. The petitioner undoubtedly is a borrower of the loan transaction and therefore can very well approach the DRT under section 17 of the SARFAESI Act. In terms of the SARFAESI Act, as he's a person aggrieved by one of the measures within bracket section 14 order bracket closed taken by the financial institution that is ordered. The petitioner approaches the DRT within a period of 30 days from today along with copy of this order. Then the DRT shall entertain the petition on merits without being dismissed on limitation of.
Bill number 20 to 30 morning go ahead.
Where is Mr. Pandey? Just a minute. Pandey have anything. Yes. 20. Oh, yes.
But as somebody here by the was there the order which was passed by the committee. The committee was seated for declaring them as a willful defaulter. As well as the appellate committee that was not communicated. That was the main demand. We have filed the reply. We have brought those orders from report. So we are living of the thing in the even if they are sending the order or if they are agreed by this order right now, they can file a fresh report. The main relief is the sort of this petition is that I got submitted the says all which types of department, but even if they have given order now, my lord, the petition is right. I have joined the law to demonstrate that those orders were not received. The reports which have been based on the power are not true. That only I'm
This willful defaulter is under that RBI scheme.
yes,
Supreme Court has held that you have to give opportunity.
yes.
Before, though the scheme does not provide for such an opportunity.
No, there are two things. What your lordship remembers will not be the problem.
Uh,
In case of guidelines, isn't it fraud law?
Hmm.
The guideline doesn't provide for
providing any opportunity. To which Honorable Supreme Court has held in Rajesh Agrawal versus State Bank of India, not that the principles of natural justice ought to be treated as a part of RBI circular, even if it was not provided.
The BRN was, you were given opportunity or not?
To be no, in this matter not.
They would not disagree that we can.
No, in fact, no, for that only I wish to place a
They were
rejoice.
given opportunity.
In fact, the petition itself admits that yes, after receiving the opportunity of hearing, the concerned director was very much there before the committee. In short time, because of certain things, the meeting could not happen. So he was very much in the.
So what you are saying is, as per their conduct, the grant of opportunity is implied.
Not in fact, it was expense. They are very much. I show everything what I'm saying.
That is a short point. Then why do we keep this petition pending?
Exactly. That's my point. In fact, the order which they did, the way petition which they filed finally was that the order was not communicated to them. So we have now communicated the order. We have brought it on record notice. Now, if any case, but if they are agreed by any conduct of the bank, they are required to file a fresh writ petition, because now by every effect now this petition has become infectious. For the relief which is sought in this city, the quashing of the order which the bank has passed, declaring them as willful defaulters, will be decided on its own merit by the ground which they are given to the fresh writ.
No,
Not the
by communicating it now, isn't it a implied admission that it was not communicated earlier?
It was communicated. It could not be received by them. That we have brought on record. We have provided the postal receipt and
The final order.
The final order and the order of the review committee. It was firstly the committee which was to be constituted, that has inspected and has declared them as a willful defaulter. Then there was a review committee of the bank. That was also passed an order. That was also attempted to be communicated to the committee.
That's a short point. Why adjournment, Mr. Agarwal?
Very small reminder. What my friend is saying is procedure. Now on merits.
From the documents, we'll be able to read whether the opportunity was actually given to you or not.
No. In addition to that, another issue. Reserve Bank of India guidelines says, and it has been already held by this honorable court, which I'll place on record, that when you issue a show cause notice, not only do you have to issue a show cause notice, you have to give the reasonable minutes of the first committee and the evidence which you have collected. Nothing has been done by them of any sort. That's the reason and this honorable court has already held. If you are issuing a show cause notice and not providing any evidence.
What does the apex court say?
Apex court says that in jar developers not versus State Bank of India, that declaring anybody as willful defaulter goes to the root of the matter. It's a violation of fundamental right. You need to give an opportunity and circular of.
What kind of opportunity?
Yes, sir. First committee has to collect the evidence, examine the evidence, issue a so cause notice and provide that evidence to the noticee. Then noticee would give a reply.
That means supply of all adverse material.
Yes, which they have never done.
When does the Supreme Court say so?
They in charge of
Decide on that.
If your lordship can give
You have a good place.
the jar developers also, Lord. I just want to place certain facts, more facts on record. Your lordship can have it after 15 days, my lord. I find that short return.
Is there any interim order? On the current counsel for the petitioner seeks time to file a rejoinder for the reply.
Yes, it is provided to me 23rd of March.
The reply filed recently by the respondent bank. Next. 2 weeks time is granted for the said purpose. List after 2 weeks.
Yes. Okay.
Number 21, P. Prakash Upadhyay.
Limitation. Limitation counted under 7B1 or 7B2A?
7B.
1. It's filed beyond 1 year.
Beyond one of my solution was that it was a period of around 4 years now. And I'm taking a specific difference of section 14 of limitation at Maharashtra because I was prosecuting the matter. After the liberty was granted, I opposed the tribunal. And there was an affidavit of Inspector as well as his counsel, and his counsel has undertaken that because of non-legal advice, he was prosecuting the matter with the high. All those orders, all those proceedings, that has been placed on record. So, Section 14, certain principle that Section 14 has to be construed liberally, and then state as a proceeding that the applicant was.
No, you raised the dispute under the clause, the in-house remedy clause,
I raised that.
29 or whatever.
I raised that.
That was dismissed.
dismissed.
Then you filed an appeal under that same clause.
I prefer what happened that in between my certain.
So there was appeal provided or not?
Appeal was also dismissed. Thereafter, it has to be referred mediation around under Adhiniam 1983. Instead of that, in between, I have prepared a writ petition which was pending before this on the board.
Writ petition challenging the appellate order.
Challenging the appellate and other proceedings. And in that proceeding, in 2015, the petition was disposed of, granting us liberty to choose the adhikaran for reversal of my dispute. Then I filed the petition. The tribunal, which was dismissed.
No, that was also a delay or no?
That was not delay. After dismissal, there was no delay. The delay was the proceedings followed which undertaken before the High Court.
How much was that time gap?
I have expect that was comes to around 4 years. My application, which was placed before the recurrent that was giving the details of all the petition and orders. Paragraph 28 is the discussion of proceedings followed. In fact, is the explanation which I have given. 27 now take applicant and the applicant of the counsel was also there.
27 of
27 of the improvement award. Even this is internal page number 24. I have a page number 24. Internal page number.
Yeah.
Yes. आवेदन की ओर से अपने आवेदन के साथ जनता का समर्थन और 7/2019 को एवं तत्पश्चात दिनांक 9/12/2019 को प्रकट करता है, जिसमें आवेदक के योग्य स्वयं ने अपने समर्थन इनके द्वारा मिसेस वंदना कंस्ट्रक्शन कंपनी की ओर से माननीय उच्च न्यायालय के समक्ष रेट याचिका क्रमांक 16/2008 4 petition पर नजर और संस्थापित की गई और उनके सतत पर मुख्य रूप से यह कहा गया है कि उनके गलत सलाह के आधार पर उपरोक्त सभी याचिकाएं माननीय न्यायालय उनका सतत का 5 याचिका के द्वारा दी गलत सलाह के आधार पर किसी मामले को सबके गलत फॉर्म में प्रस्तुत किया गया है तो उसमें व्यतीत किए जाने वाले समय को अपवर्जित करते हुए उसे क्षमा कंट्रोल कर देंगे। क्षमा करके मामला प्रस्तुत करने के लगे समय वर्तमान याचिका अधिकरण के समक्ष प्रस्तुत की गई उससे समय सीमा में मानी गई, लेकिन अधिवक्ता का समय पर स्वीकार किया जाना योग्य नहीं क्योंकि माननीय उच्च न्यायालय के निर्णय आदेशों को बारंबार याचिका के समय व्यतीत करना स्वाभाविक नहीं कहा जा सकता। श्री त्रिपाठी ने आवेदन में अनुचित लाभ पहुंचाने के लिए गलत सबूत दिया है। Now 28 is the reply by the respondent. Thereafter, my lord, the final discussion is at paragraph 50. अभिलेख तथा विद्यमान परिस्थितियों से स्पष्ट है कि माननीय उच्च न्यायालय द्वारा याचिका क्रमांक 5260/2011 में पारित आदेश दिनांक 20/5/2011 के अनुसार से भी माननीय उच्च न्यायालय के आवेदन को अल्टरनेट आर्बिट्रेशन रेमेडी उपलब्ध कराने बाबत आदेश को लिखित किया, लेकिन उपरांत भी आवेदन द्वारा विधिक उपचार के अंतर्गत जागरूक नहीं है, उसके द्वारा आर्बिट्रेशन और के अंतर्गत कार्रवाई नहीं की, तभी उसके द्वारा तत्पश्चात आरसी बाबत जिला न्यायालय विभाग के समक्ष उसके उपरांत माननीय उच्च न्यायालय जबलपुर में समक्ष याचिका क्रमांक 8860/2013 से स्थापित की गई जिसके निराकरण 3/8/2015 में नेक्सट 319 हुआ, जिसमें उसमें भी आवेदक की याचिका उसे अधिकरण के समक्ष समुचित विधिक उपचार प्राप्त होने के आधार पर अतः स्पष्ट हो जाता है कि आवेदक की अधिवक्ता श्री शिवांश को पूर्व में आवेदन के अधिकार है, उनके द्वारा भिन्न भिन्न याचिकाएं प्रस्तुत की थी। अतः ऐसी दशा में यह नहीं माना जा सकता कि आवेदक के अधिवक्ता की गलत सवाल के आधार पर आवेदक के गलत फॉर्म का चयन आवेदक के सपोर्ट पर विश्वास नहीं।
So it's a period of about 2 years.
But it is period of about 2.
And where is the order of the High Court?
The order placed my lord on record along with my applications, my lord. Limitation application, my lord, which is the part of the record. All the annexes have been placed. This has been filed on 27/8/2015. It's the part of the record of the. You will not see it is on the scanned document. It is at page number 81, my lord. The complete scanned document is taken, and internal presentation is 17.
81 is not there. It's not there.
But it is scanned as copy of AR 9/2021, my lord. It's available on the website of the report, my lord. It is captioned as other copy of AR 9/2021, 24/320.
You said 81. At page 81, it's not there. And this is a copy of AR. You have filed this, I think.
But it is on the scanned document, my lord. The record of the tribunal itself is scanned by the district.
In that 81 page, it's not there. Which is the other page?
It is 17, my lord. Page 17, which has been written.
17. 17 is part of the award. 17 is a part of the award.
It says from the ERP level.
Award is still page 26.
No, it is not filed by me, my lord. It is scanned by the registry. And it is scanned out the file in this copy of AR 9/21, 2021 _ 2024.
Where is the synopsis of dates, chronological dates, which are relevant dates?
It's not on the record, my lord. I will prepare the dates. Because it is provided in that particular IA itself, my lord.
24/6/2006 is the order of the High Court. Where is that? 24/3/2006.
That my contribution of delay application which has been filed is at serial number 8 under tab E, my lord. In ERP, my lord, it's a tab E, serial number 8.
Since number of dates would be relevant to decide the issue involved, limitation, that synopsis mentioning the dates in a chronological manner be filed by the petition. List after 2 weeks. Where is Mr. Pandey? देखिए पांडे जी को बुलाओ थोड़ा पास में petition ignore कर दो 2019 का ऑर्डर 5 लाख yes
Then number 22 is connected matter कि मल्लिकार्जुन करे अदिति श्रीवास्तव आदित्य नायक
yes so the suit had awaited because of expiry of 90 days. So can we send it back? Now you file an application, continuation of delay. For setting aside the abatement along with an application for continuation.
There is an original application also which is filed under section 19 of RDB. And in that proceeding, with the consent of the bank, LRs of the same deceased person have been brought on record. With the consent of it. And that order is not placed on record along with it. That's one part, my lord. On the other part, that limitation issue, my lord. I'm told, my lord, I'm here to lay my hand that Honorable Division Bench of lower bench of this High Court, my lord, has dealt with the issue relying on your lordship's order in Honeywood, my lord. Additional findings have been given to say that the BRT would have a power under section 5 to condone. That order is yet to, I'm yet to get that order, but that also needs to be placed on the board before the lordship. That's a recent development.
So the residential value of Anirudh has been doubted by us all in the subsequent order saying that since now the matter is pending in the apex court, the apex court had decided the issue as regards appellate forum is concerned, but had not decided the issue as regards section 17.
That's what I'm saying, my lord.
So it is pending. So we said you decide, we sent the litigant, the aggrieved party to DRAT. The DRAT should decide on the law which is prevailing right now.
But here in this petition, there are two questions. One is with respect to applicability of the limitation. And secondly, with respect to abatement in a case where only one applicant has filed a return. And the sole applicant.
What do you propose today?
So, but that your lordship's order is Honeywood. Although your lordship has doubted blood based on that other matter, blood justical matter. But in that power of appellate authority, but there was a not finding or law laid down, but there was an observation about section 17 proceeding also, based on which your lordships were convinced and your lordship had said that blood power is there. Now, your lordship's judgment has been considered by the division bench, lord, and further findings have been given, my lord, on its own, not even on your lordship's judgment, my lord. Even that needs to be placed before your lordship of the division bench.
The learned counsel for the party are at consensus that certain that on the same issue involved herein, certain subsequent orders have been passed by other benches of this court. which needs to be placed on record and therefore short time is short. This is the case after 2 weeks. I have to continue.
For we to directly supply the funds for which that
Yeah.
the particular circumstance in this case is not on the judgment of money. That the article controls. About the 19 please you first come to the next item, which is at page number 20. The next appeal.
Next, sir.
P200 at page number 20. So this was the first securitization application bearing action number 744 2022, which was dismissed on 7/12/2023. Once between the same parties on the ground.
Where does Anirudh Singh find mentioned here?
I just clarify for my lord, I'm just giving a brief background. By way of this order on 7/12/2023. The first securitization application was dismissed on the ground that provision of Section 5 of the Infectious Act is not there. Court may have this finding at paragraph number 1819. Of this order.
You are for? Who are they? Or
For the is listed on 18 before the DI. It's secured of it.
Also, there is a judgment pathway to although my lord, the judgment of this on the court part is everything has been relied on, but court has given finding in respect of the act. So the point is the act. Section 79. But it will have the presidential way. That even the multiple dishonorable putting other two has been very directly observed. So by way of an interim order, it was court has doubted its own order.
the counsel for the respondent, you are for the
1 and 2.
then 2 followers. Take time to reconstitute his file. Just after 2 weeks. 18th.
Finding up to page number
18th is today is what?
as per the matter of posted, which is first a lot of stand aside.
Fix an adjournment next since urgency is expressed by learned counsel for the petitioner, as the matter in the DRT is listed on 18th. List on 6th. List tomorrow.
After 2 weeks.
ये वो साथ ही रहेगा. Along with 2 weeks के बाद. Mr. Pandey, this order is of 2019. Like you have virtually, we have virtually condoned the delay of 5 years. In 19 May, Section 14 order, 2019. So we are condoning a 5 years delay just by one stroke of pen. So we'll say that the law of limitation will apply. You'll have to satisfy. All right. Yes.
Number 23, P.Ed Pratap Singh.
Pertaining to that was working since last 10 years. And even during the petition, the petition was also since last 10 years. So the instruction petition of the petition, a foolish time to come in.
Why is this petition come to the division bench?
Not this one, asking the lawyer rights to. The Tabular matter has specified the children's.
But you are seeking a direction for deciding a representation. So why has this case come up in the division bench?
So, and with the matter issue,
Yeah, so that is division क्यों है?
Tabular matter has been decided on the P1 P2 and P5.
Transfer from Bolivia. We have a list. Contract teacher. So, single bench हो गया था. Single bench था. No case. Similar nature.
प्रिंसिपल नंबर दिया है वो बीबी के लिए बोले नीचे करके पहले पेज में सबसे पहले पेज
Single bench. Single bench is single bench.
स्क्रूटिनी रिपोर्ट लगी मिला है बीबी टू
And that is rated on bench. Track teacher grade 3 is pending. We say that prima facie it appears that the present issue relates to the roster of single bench. Next, however, the office note 12/10/23 directs this matter to be listed. Directs opines that the matters are listable before the division bench in view of WA 316 of 18, State of MP versus Srimati Shaheen Anjum. Pending before the division bench in regard to issue of contract teacher grade 3 and WP 1 of 18. Next. List along with WA P16 of 18 and WP 1991 of 18. Another corrective measure in the next week.
Year number 24, Rajiv Misra, petitioner person.
Also, All right, pass over.
Year number 25. Sobri Man Singh.
For not considering the result. Although mother of the last people was mother non-sitting of the match at whatever. That is because they only see can see their mom. That their mom. It's going to be free. That is not going to be fair. And my limited grievances to the cat only mother that they are not considering me for the interview. And same has been considered mother during the pendency of the case. Only about mothers. That is the only very unit I am stating. Case is transferred to the branch mother considered by limited term. Because the petition mother, the mother directly the respondent to the last time also mother.
But that OA is still pending. That is 432 of 23. And for transfer, you have filed MA 233. That is also pending. There is a sitting these days. When did you file this MA? 9 February 23. 24. 23 की registered है.
Last time.
No, your prayer does not mention anything about MA of 24. It only mentions MA of 23.
See the transfer 432 the last one.
That is not MA, that is OA.
Page number 72.
I am seeing your prayer. Page
number 72. Like the P9. Page number 73 by MA. 432.
So in this MA 233 of 24, your prayer is what? For transferring which OA? Where is that prayer? Please come to page 75. Not mention any OA number. OA number is what?
72. But OA number, I make a prayer for transferring these
72 of
like the P9. P9.
what is the OA number?
432.
432 of
2023.
23.
Particular OA number.
But that is pending in Gwalior.
This OA number for transferring my OA to
This is pending since 9/2/24. Where is the power?
section 29. Last time also my transfer is my OA from the bank to system.
Why was the transfer?
Sitting at 40%. The reason I paid the model, the answer
Then you want it back now.
it is not sitting for the Tribunal Act. take at the volume right, but for the second engagement marker they announced. Again, I want to back marker so that match will be decided. I might again it would take 3 more months. Taking that marker high, one single sheet will be going to fill marker. This can take something from cancel marker. And then
What's
down
this case for the- This was directed to be listed at Gwalior on 12/10/23. Then it was taken out.
No,
There was no sitting.
no sitting.
Since then, there is no sitting. What is the urgency?
I'm not going to declare the reserve marker.
Vacancy of what?
Assistant commissioner.
Assistant Commissioner? Which department? Railway.
It's something from cancel market. This time it is Munda market, Japan Munda. The only claiming that market is the declare market. This particular post will be- I think it will take at Japan market. In the last, some days market, at least he will be with his family member market. But it's very difficult for him to stay Korean market.
What is the prayer in the OA, main prayer?
Consider for interview.
When are the interviews?
So we want to and see one grade number 71. Next FPA. Allow my all for the hotel interview was 3rd of July.
On July 23.
I can see page number 71 and HFP mark.
Then what is the result of the interview?
The wedding mark because of the order of my lord mark. 69.
Next one.
37 mark. Already directed, it should not be declared. See the last one, I think consider and decide applicant petition is concluded within 15 days. Result of SH category on the proof of assistant commission shall not be declared till further order.
What is this HH category?
So hearing. Now I'm getting the fantasy of this.
You belong to this category. Where is Mr. The other side? केंद्रीय विद्यालय के लिए कौन? There is some standing counsel, I think. Let a copy of this petition be served on the standing counsel in the High Court or Kendriya Vidyalaya Sangham. Just the case on 18th April, mentioning the expression standing counsel KVS in the cause list for response.
Number 26, Mithun Shukla.
उसको मेहंदी आता है स्टैंडिंग काउंसिल और you serve a copy. Which case? 26. 26 में क्या हुआ? Madhur Shukla. Yes. Why after 2 weeks? Informed by क्या नाम आपका? Ashish Thakur, the argument counsel is unaware. List after 2 weeks.
Number 27, CCS
Charge sheet filed or not? You can file a soft copy also if you want. The petitioner Seeks and is granted further time of 2 weeks to comply with order 12/3/20. List after 2 weeks.
Number 28. Chauthi Asim George, Alfred Chaudhary.
But बच्चे आना भी नहीं चाहते, mother already ran it, तो बच्चे के पास आ गए.
So let the other side be also. And where is the other side? तो पास ओवर करते हैं, बुलाइए उनको बुलाइए.
Number 29, this connected matter, Sri Rajesh Manju Gupta, Kumar Tiwari.
One is this matter. Connected matter mother they filed under audit committee. They are filed from the board. Date of 6th of May, Maruta, has to come from Delhi.
Yes. When do you want?
On the 6th of May.
Any objection? The counsel for the respondent, borrower.
Well, neither I am the borrower nor I am the guarantor manor, and property has wrongly been mortgaged by the other respondent's manor. So it has been very well said by the DRT as well as by the DRT that the property has been wrongly mortgaged. It belongs to the respondent number one entity. So neither I am the borrower nor I am the. So I am the third party.
Counsel for the respondent, number
1 month.
1. Yes, for some time to enable an outstation senior counsel to argue the matter. When do you want?
6th of May.
As paid for list on 6th of May.
Okay.
Number 30, Vasant Raj Pandit.
Mediator की report देखिए. हाँ. ये mediation में क्या हुआ? Don't start up. आप जेल में होने की वजह से कुमार यादव वाइफ कौन जेल में कौन है वाइफ किस ऑफेंस में ये ऑफेंस क्या है अच्छा जेल में कराई जा सकती है वाइफ बस पिलाते तो हम बस बहुत ये हस्बैंड की डाइवोर्स पिटीशन डिसमिस हो गई है। तो हस्बैंड ने तो कहा है कि भाई ये संभव नहीं है समझौता। Latest reports also indicates that the husband has expressed his disinclination in entering into a settlement with the respondent wife. Next one. Next one. The order received. He being arguable is admitted for hearing. List for final hearing in July. I have a document taken on record. Do you know उसको allow कर देना? Documents will be taken considered at the time of hearing.
भावना है लोगों के साथ में मिलकर साथ में करेंगे और नीचे का
ये आप दोबारा इंस्ट्रक्शन सीख कर लीजिए। वी हैव लिस्टेड इट फॉर फाइनल हियरिंग। अगर बीच में कोई संभावना बनती है तो बताइए, एप्लीकेशन लगाइए।
नंबर 31 याकिर सिंह सिंह वगैरह
7 लाख आपने दे दिया है? The current counsel for the respondent husband needs further time to tender the amount of rupees 7 lakhs as permanent alimony, as agreed to by the parties as one-time financial support. How much time do you want? Just after 2 weeks, the week commencing 29th April.
नंबर 32 सुशील कुमार दुबे
Who is for the wife? Nobody. तो इसको फाइनल हियरिंग में सुन लेते हैं. Since no one appears for the wife, right, being served, list for finding this appeal, which has already been admitted on 20th March 24. Final hearing in July 24.
नंबर 33 with corrective letter C. Ramesh Singh Thakur,
My lord,
Venu Kumar Case.
Lord, this item number is 1378/22. Lord, there are two petitioners, Lord. Both of them have been given the appointment order. So, Lord, I am filing these appointment orders today. So, I did not file it because matter was disputed today.
No, in this you are for the respondent.
Lord, in this case, I am for Lord, I'm for the B.Ed candidates who are already working, who have been granted permission by my Lord to be applicants. My humble submission in this case is that there are two petitioners in this case, A.P. Nandan and Rohit Chaudhary. Both of them have been granted appointment.
They are diploma holders or B.Ed holder?
No, they are diploma holders who have succeeded. So, Lord, now there is no need for them to.
No, it is let the counsel for petitioner say whether it's become infractuous or not.
No, we are for the petitioners. We are for the petitioners. If I may start, if my learned friend would let me start.
We will see, my Lord.
Sir, if you let us start, if you don't mind, can we start?
My lord,
Just a minute.
My lord, Mr. P.S. Patwalia is appearing in this matter, my
I
lords.
oppose, my lords, we oppose any kind of adjournment. Can we at least start? We have
No, not in adjournment, my lords. He's on his legs before the Supreme Court. My lords may just pass over this matter and take it at the end of the board or at 2:15, my lords.
let my learned friends say that KC Nandan, Sahu and Rohit Chaudhary have not been given appointment. On his oral statement, let me permission be refused.
My lords, I'm sorry, there has to be some procedure that the other side needs to understand. Can we at least?
Mr. Counsel who are appearing virtually, please do not speak unless the court asks you to. Please wait. Please wait for your turn and please switch off your audio.
Apologies, my lord.
Yes. Just a minute. So who is appearing in 13768 for the petitioner? Has it become infructuous or not?
It has not become infructuous.
It has not been an infraction.
Not given any appointment I have given the.
नहीं आप परमिशन तो देते हैं उनको फाइल करने की we will see. Yes.
Order of Devesh Sharma is prospective in nature. And appointments have been honorable advocate insisting on this matter the and maybe about that can be taken up in the next week. Any case.
Lords, we have filed a compilation of
Go through the order. It's not a very long order. Decided right now. Doesn't matter. We only have to follow the order. That's all. If there is any complication, if there is any obstacle that we cannot decide today, then we will. We have no problem.
Commission is that it's 1, 3.
All right, so let us first.
Then we can argue the other case.
Let us first read the order of the Supreme Court.
We will not do any the petition of 137.
No, we want to do the academic exercise. Can you stop the court from doing it? So please, can you stop the court from reading the order? Let us at least read the order and then decide what to do and what not to do and when to do and how to do. Yes.
The operative part is internal page 7, last part. Operative part of the order. Internal page 7, last paragraph.
Yes, sir. That would get themselves. So there are a lot of conditions in this order. So there has to be a table prepared by all of you. Now, like for instance, it says one is that it will be prospective, number one. Number two says only those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that it will remain subject to final outcome. And such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was stipulated as a valid qualification. Now, this benefit is only for candidates who were appointed prior to the date of judgment, that is 11/8/2023. And then, of course, that bridge course. So, first of all, please prepare a chart, all of you, that who satisfies these conditions.
My lords, we can prepare the chart. That should not be any issue. But I would like to say this, that there are interim orders that were passed by my lords, and the appointments made in the present case for my lords, many large number of them are subject to the outcome of the present petition. And my lords, each one of those orders is before my lords here. So that clearly is covered by that page 7.
Either you prepare or I'll ask my law clerk to prepare it. We'll also do it. We'll do it and we'll prepare the chart. And
my lords,
I don't know whether all of you will.
So in fact, that chart is present in the affidavit filed by.
You all are rival parties. You may not come together. Meeting of minds may not be possible. So we'll do it. We have a law clerk. We'll ask the law clerk to prepare it. And whether these conditions.
My lords,
the state of MP
my lords,
filed it.
as counsels.
Evident from the record, you don't have to seek instructions from your clients.
Yes. My lords, as counsels, there is no question of meeting of minds. We have to go by the record before the court. So therefore, my lords, we will go only by the orders that my lords have passed and the outcome of those orders and the statements made by the state of MP in its affidavit, how many people have been appointed when. So fortunately, we have one of those affidavits where they have made categorical statements to that effect. So, my lords, that will be basic.
Can you make a common table?
It is already there.
Yes.
Both the sides. You all have to sit down on a common table, which may not be possible.
I offer a copy to my
Would my lords consider seeing page 34 of the company?
Yeah, temptation for them. You may have to provide something more.
No, my lords, if your lordships can make it clear, my lords, if your lordships make it clear in the order that what is actually required from both the sides of the councils, because one thing is very much clear, my lords, that when the advertisement was issued, it was challenged. Your lordship passed an order that because the matter is pending before the Honorable Supreme Court, entire process will be subject to the outcome of the Honorable Supreme Court's order in Devesh Sharma's case. Subsequent thereto, my lords, the appointments have been released by the state government.
So, Mr. Shah, let us first prepare that. Our law clerk will do it. The court will not depend upon the data supplied by the parties because they may not come to terms.
Because it's already on record.
And we can list it on 19th.
Well, can I just see
18th or 19th, whichever is date convenient.
19th, my lords, and 19th.
Can I just take 30 seconds if my lords will permit just 30 seconds?
19th is the polling day. All right, then 22nd.
Well, can I just take 30 seconds? The chart is already ready.
Doesn't matter. 1 day will not make a difference.
Can I just take 30 seconds, Maloj, if Maloj will permit?
Yes,
the chart is
yes,
already ready, Maloj. The chart is already ready. It is before my lords in a compilation at page 34. The state of MP filed a chart before the Supreme Court. Can we just show that it will resolve the problem? The chart is filed by the state of MP in an affidavit before the Supreme Court.
That Mr. Karla must have been filed prior to the order of the Supreme Court.
No, it is filed for the proceeding in the 8th April order. When the 8th April orders was pronounced, that time the state of MP filed a chart. and that chart answers all the queries as my lords would want to know about. All those queries are answered in that chart. If my lords could please have page 34.
Just one
Chart
step.
and in which case? Which case?
My lords,
is a
it was
con-
filed before the Supreme Court in the present application filed by State of MP. That is where I said that fortunately there is an affidavit which has been filed by State of MP. The State of MP in that affidavit filed in the present application in which this order has been passed at least has set out the dates on which it gave the appointments. Now, my lords, those dates have to be juxtaposed only with my lord's orders. My lord's order saying that all appointments will be subject to the outcome are prior to these dates of appointment. Now that takes care, that is completely in accord with with the Honorable Supreme Court's order at page number 7, my lords, the last few lines and over to page number 8. So that is probably the only comparison which we can't have a better thing about the dates of appointment than the statement made by State of MP before the Supreme Court in the current proceeding itself.
So where exactly is the chart in this compilation?
My lords, yes, page number 31, my lords, in this compilation, and if my lords will come to page number 34.
We don't have a copy of this compilation.
No, everyone has been
Please
served
bring
with the
that chart that was filed. Please bring that chart which was filed before the Supreme Court on record.
Page
It's
34.
contained.
It is not, we don't have a copy.
Sir, you were a
My
party in the Supreme Court. Why should you delay such matters, please?
The Supreme Court records are not part of the records here.
My lords, your lordships would only be required to look into this fact whether the appointments have been issued after the interim orders being made subject to the outcome of the Devesh Sharma's case. If the fact remains the very same, if this is to be placed by the State of MP, the dates when the appointment orders have been issued, those were issued after the interim order was passed by this honorable court. So, my lords, all those would be now covered by the Supreme Court verdict that they cannot be retained in service. So, my lords, the State of MP can very well tell those two dates of appointments being issued.
It's meant. Please see page
Which is-
34 for a minute. Please see page 34 for a minute. It is specified there.
All right. So we direct all the parties to give a tabular illustration based on the order of the Supreme Court latest by 19. So that we can take up this matter on 23rd.
My lords, can I make one request to the court, please? My lords, so far as the dates of appointments are concerned, State of MP is the best authority to give those dates. We will not be able to give you the dates, save and except for what is stated by State of MP on record before the diverse courts. So let State of MP at least put before my lords the dates on which it gave the appointment. The rest is a matter of record of proceedings of my lords court, proceedings in the present matter.
You have to give precedence to the lady. Yes.
My lords, may I
And that
just
to senior
reiterate?
advocate, my lords.
Even otherwise.
My lords, that's all right. I know people are anxious, but I'm still they are kind enough to allow me to go on. My lords, I was saying that
Yes,
so far as
please.
the dates of appointments are concerned, State of MP
Yeah.
is the best authority to give the actual date of appointments. Now, all that has to be seen is the actual date of appointments and in contrajunction with my law interim orders that had been passed, that any appointment will be subject to the outcome. If those appointments have been made after my lord's orders in the present proceedings, then clearly those appointments will go. But if the appointments have been made before my lord's interim directions, then perhaps they may be sustainable in view of the Honorable Supreme Court's orders. So, my lords, we have a benefit of this affidavit that was filed before the Supreme Court on 6th of April 2024. But the State of MP, let the State of MP file before my lords by the 19th or so, the dates of the various appointments that it has carried out in these present proceedings given to the B.Ed candidates. My lords, I think that will be important because then it's a very simple exercise. It won't take too much to be done.
Exactly.
And the date of the order passed by my lord is 7th July 2022. 7th July 2022 is the interim order passed by my lords. So all appointments admittedly are after that. My lord would see the 7th July 2022 order.
We made that table.
Well, इसमें लिखिए that parties are on. Counsel for the respective parties are on. Next. The Apex Court, by its order dated 8/4/24, has decided the review filed by the state of Madhya Pradesh. State of Madhya Pradesh. Review by state of Madhya Pradesh.
My lords, it was an application for clarification. It was an application for clarification. It was an IA. It is noted in that order. My lords will find in that order of the Honorable Supreme Court, my lords will find that the court notices the nature of this application. At page number 5. Application has been filed, taken out by state of Madhya Pradesh, labeling it as an application for clarification. My lord, second paragraph, page 5. It was not a review, but the Honorable Supreme Court then proceeded to treat it as one.
No, they have treated it as a review.
Yes, my lords, they do go ahead and treat it as review.
Has clarified the its earlier judgment passed on 11/8/23 in the case of what were the parties there?
Devesh Sharma versus Union of India.
Union of India. The aforesaid judgment in Devesh Sharma has been made prospective, but certain conditions, as contained in the said order. Next. Certain relevant data and documents are required to be filed by the respective parties, especially the state of MP, including the various appointment orders of the B.Ed appointed, so that the can be implemented resolved. Next slide. The parties are directed to file a common tabular illustration containing all the necessary and relevant facts and documents in regard to all the parties in these petitions. Are there some other petitions also? No. Besides what are listed here today, any other petition? Okay. These petitions, latest by 19th of April, latest by or like 22nd of April. List the case on 23rd, as agreed to by the parties.
My praying, my lord, please
consider
my idea number 528.
IA 5284 of 24 filed today by the
interveners in 13768 of 20.
Shall also be considered on the next day.
Would my lords consider fixing some time on 23rd minute?
They are at liberty.
Would my lords
They are at liberty.
would my lords kindly consider fixing some time?
Argue on this issue. That KC Nandan does not survive. And the moment KC Nandan goes on, nothing is there in the
Look, it is an argument by someone whose intervention till date has not been allowed.
Would my lords consider fixing some time on 23rd minute?
Even his intervention.
Counsel who are appearing virtually, do they want any time to be fixed?
Yes, my lords.
Yes, we want the time to be fixed, my lords, but only with the request that instead of 23rd, it will be taken up on 24th.
We are comfortable with the convenient to my lords, but some time may be fixed.
At 24th on fixed.
It will be 2:15 at on 23rd itself.
By 24th, 23rd there would be some problem. 24th if it could be made, my lords. May I request for 24th, my lords? 24th.
Yes. Any objection to that? 24th. 15 years.
24.
Okay.
Please tell us who is appearing for whom, one by one. Huh? No, can you all who are appearing for virtually, you are appearing for whom in which case?
I am appearing
Miss
Madam
Arora
Kumar Dwivedi.
Ms. Arora and myself are appearing for the petitioners in the three matters, Manoj.
How do you inform us then in writing?
Manoj, our local council will give the appearance in writing.
So please put it in the chat box.
We will do so, Manoj. We will do so.
We'll do it, Manoj.
I'm appearing for the interveners, the B.Ed candidates, appointed B.Ed candidate. Mr. Patwalia was leading us, Millard. I'm in the other matter, the Vipin Kumar Dwivedi matter. Our intervention application stands allowed, so we are respondents.
So please put that in the chat box. So
Manoj,
that
we'll provide the same in the chat box.
So it is 24th of April, 2:15 p.m.
In fact, Manoj, all other high courts have decided these issues and confirmed by the Honorable Supreme Court in the past 1 month, making it all the appointments which were prior to the judgment, but post the interim order have been rejected. All high courts across the country have done.
That is the view of my friend Millard. We have a lot to say.
All right. WP? It is not listed today. Along with WP? One three.
768 will not survive. उससे कोई लिंक करने का मतलब नहीं, my lord. I miserably fail to understand why they are pressing 1376. Judgment of the Supreme Court.
13768.
It's not a PI.
You are B.Ed appointees. Then what is that? You are already appointed. No, we are talking about there are only 2 persons in 13768.
Yeah.
Persons in 768. That must be some other petition. Which is that number?
Issue is not the same. Issue is entirely different.
Mr. Rupa, just a minute. नहीं आप बताइए वो उसका नंबर क्या है? 10087/2024. ठीक है, कोई फ्रेश केस लगाया है?
What is it about, my lord? We don't want necessarily creating, because with great difficulty I have succeeded to sort out AC Mandar and Vipin Kumar. Unnecessarily they are much clear.
Well, it does not become infructuous. The prayers in 13768 may be seen. I don't understand that why is this argument being canvassed that it becomes infructuous. We see the prayer in 13768. It is by D.Ed candidates. The prayer is identical to the other matters.
My lord, that may be argued.
And I understand the petitioner saying it becomes infructuous. An intervener who intervention is still not allowed is saying this.
Yes, unnecessarily, Lord, this is a vexatious litigation case in Nanda. So this Vipin Kumar Dwivedi, they have not been appointed. So Vipin Kumar Dwivedi, I will argue why we should be compelled to argue.
AC Nanda and the petitioner too have been appointed.
Yes, both of them have been appointed.
I'm sorry,
let them say so. Just a minute, Mr. Kala. Please, Mr. Kala. Yes. So then, why should we continue with the petition? That has been settled by the Supreme Court now. They are not aggrieved by the order of the Supreme Court. They are. How are they aggrieved? By the appointments of the diploma holders has not been said by anybody. They are, and you will continue in service. It is only the B.Ed candidates who are apprehending a termination or being ousted from service. How are you concerned?
That is the exact prayer. Please see the prayer in KC Nandan Sahu for a minute. That is exactly the prayer that B.Ed should not be treated. Please see one of the prayers at page 29 of the petition, Malaj. And that can
has been given to you by the Supreme Court.
So therefore, all that we want is this petition be allowed in terms of Supreme Court order. That's all. That's all. Other high courts have also done where similar prayers were made. That is what we have produced on record.
That has been set aside by the Supreme Court.
I'm sorry, Malaj.
Huh? To the extent? What is the prayer? Let us see.
Please see page 29 is the prayer of KC Nandan Sahu. 7.2 and 7.3 are very important at page 30.
It cannot be a co-one that is the legal position. It cannot be a PIL that also we know the legal.
But if you don't let us argue, how would we argue, please, if you don't mind?
If matters, PIL does not, is not maintainable. And valid.
Malaj, kindly have para 7.2.
Sorry.
If I may read 7.2 for a minute.
Either you are agreeing with your appointment, then you.
So Mr. Thakur, 7.1 you have sought quashing of this notification which has already been quashed.
Indeed.
Not quashed. Then we come to 7.2. Please to issue an appropriate writ direction not to treat B.Ed candidates. That has also been held.
Indeed.
Certain conditions, certain clarification is there. And even if those clarifications are read in favor of the B.Ed candidates, you are not prejudiced. Because you hold the diploma, which has been treated as the correct qualification. Then 7.3 is what? Liberty to the state to treat so and so. So and so. BSTC candidates क्या है? Huh? BSTC क्या है? What is this BSTC? Eligible for appointment cost of found a very clear. Detailed number of such trained. So this is also satisfied now. Nothing remains.
BSTC Malaj were asking, stands for Basic School Teaching Course. Teaching Certificate, I'm sorry.
Is also done now. 0.4 is also over there. And 7.5.
No, 7.3 and 7.4 is not over. If I can intervene in between, if your lordships, there is some, because actually we left it believing that the matter has now been posted on 21st. But I've been apprised that there is some objection raised regarding the matters becoming infectious, which is not the position.
And all that we are praying is this writ petition needs to be allowed in terms of the Honorable Supreme Court's direction.
Plus, if two candidates in a bunch of the petition of two persons have got the appointment, will not render the entire petition infectious, because it is about the validity of the rules, the qualification to be prescribed, and thereafter the appointments to be given only those who are eligible as per the NCT initial notification once the notification of 11th August 2023 was quashing set aside.
We'll take it up on 24 then.
My lords. Obliged ones.
All petitions on 24 along with WP 10087 of 24 as prayed for by Sri Chan.
Obliged ones.
Grateful, Malaj. Deeply grateful.
Interim order doesn't survive now after the Supreme Court judgment. हाँ, so it does not survive. आज पता लगा है तो नहीं अगस्त में कहाँ आ गया? नहीं, तो उसका clarification आ चुका है. हाँ, so now it doesn't survive. Yes. Yeah. Okay. We'll come back in 10 minutes.
Grateful to my lords.
Wait for minutes.
And with nothing at the round.
Yes. What one नाम दे कि डाल दिन नाम आपको पता है तो जितना वो है सभी रिजर्व लेक कौन रिजर्व लेक हमने की डाल और एक विज्ञान सार है मैडम चलिए मैडम हाँ हाँ ठीक नींद
सिक्योरिटी इंटरेस्ट हाँ कौन सा रूल है रूल 13 ठीक है फीस फॉर एप्लीकेशन ठीक 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 है
Bill number 34, Neelam Kumar Saha.
Forty-four. What is it? First appeal, fresh case. इलेक्शन नोटिस दूसरी तरफ से कौन है? हो चुकी है. Delivered on 1810. Let record be requisition. List after receipt of the record. So, one so for the white, none for those despite.
Bill number 25.